Hey everybody, it's Christopher Small, the owner of CMS Law Firm. We do estate planning, we do probate, we do it well. Today, I want to talk to you about whether or not you have to liquidate investment accounts when someone dies. Before we get to that though, I want to remind you, if you have questions about this or anything else related to estate planning or probate, and you want to talk with us over the phone for free, you can do so by going to cmslawfirm.com. cmslawfirm.com. Okay, this was a listener question. As always, before I dive into this answer, I want to encourage you to reach out if you have questions, comments, or anything. If you are watching this on Facebook or YouTube or anywhere else you can leave a comment, leave it. I will see it and I will answer your question. And if it requires another video, I will make another video for you. But I'm happy to do that, okay? That's where this comes from. Somebody wanted to know, do you have to liquidate investment accounts when someone dies? The answer is most of the time, no. All right, so the answer is going to be it depends, because there are some situations when you might have to do that. But generally, someone dies with an account. Let's say like have a Charles Schwab account, right, investment account, and they give it to somebody via beneficiary designation. So they say, you know, Joe Blow is going to get this account. What will happen is when the person dies, the death certificate will be given to the account administrator. The account administrator will say, okay, I see that this goes to Joe, and they will talk to Joe. What do you want to do? Joe can do a couple of different things. What he will probably do and should do, at least right now, because you get to step up in basis. If you haven't watched my Joe Biden video, go back and watch it if you want to learn about what might happen. But because you get to step up in tax basis, what you will likely say is, hey, I want to move this over into my own account, but I just want to keep everything as is. So I want to keep all the same investments, I want to keep all the same things, move it over, and all of the stocks, all of the ownership interest will transfer from that account to your account, and everything will stay the same. The same thing will happen if it's a will as well. So if somebody dies and they give their investment account via a will, after you open probate, the personal representative or the executor should talk to the beneficiary and say, how do you want this account to be handled? And they could say, I want to liquidate it, or they could say, I want to have it transferred into my name, when they will do the same thing. Now, the one time when you might have to liquidate an investment account is if estate taxes are due, or if there are very large bills that are due that need to be paid. So they follow the creditor claim process correctly, those bills need to be paid, then you could need to liquidate some of those assets to pay those bills. If you have estate taxes and there's no other way to pay the estate taxes that are owed, you would have to liquidate some of those funds. Now, this is more likely to be the case if someone has significant retirement accounts and significant life insurance proceeds, because at least in Washington State, by law, those items are not necessarily attachable for those purposes, okay? Now, if they just flow into the estate and then get transferred out, they could be used. But if a life insurance policy has a beneficiary on it, for example, it's very difficult, legally even, to get the proceeds of that life insurance policy to help pay for outstanding debts, to help pay for estate taxes, to pay for those things, okay? Not impossible, but very, very difficult. So that would be like the only time that I could think of off the top of my head when an investment account would be liquidated, kind of no matter what anybody wanted to do, only because those bills need to be paid before any distributions can be made anyway. All right, so to summarize, to recap, the general rule is you can roll those assets over to your own account. You can transfer them over if you want. You can liquidate them if you want. You're not required to do anything, sort of whatever you want to do, unless those assets are needed to pay bills, to pay estate taxes, or to pay other things. Then it's likely that they would be liquidated at that time to pay at least down those taxes or those outstanding debts from the decedent. Okay, that's it. Hopefully that made sense. If it did, if you like this video, please hit the like button. If you have a question or comment, let me know. If you are any place where you can leave a review, do it, okay? I enjoy hearing from all of you. I hope these videos are helpful. If they are and you want me to keep making more, let me know. Give me some love, okay? Other than that, as always, if you have your own estate planning or probate questions and you want to talk with us over the phone for free, you can do so by going to cmslawfirm.com. Sign up right there and set up a time to talk with us, okay? cmslawfirm.com. All right, everybody, as always, I am Christopher Small. I'm the owner of CMS Law Firm. We do estate planning. We do probate. We do it well. Thank you for your time. Thank you for your attention. I appreciate you, and I will talk to you again soon. See ya.